4 reasons why you should not get a living will. My name is Leon Jones Jr., and I'm the managing attorney here at Big Rock Legacy Law Group. And we advise our clients on the importance of planning for the future, buying insurance, setting up retirement accounts, drafting wills. And one document that frequently comes up in these conversations is the living will. It's typically praised as a safeguard, something that ensures your medical wishes are followed when you cannot speak for yourself. But today I'm here to challenge that narrative. I want to offer you a different perspective, one that isn't commonly discussed. Living wills, despite their good intentions, might not be the best solution for everyone. In fact, you can create confusion, limit care, and even put your loved ones in emotionally devastating situations. So let's dive into 4 compelling reasons why you should not get a living will. Reason number 1, living wills are often vague and they could be misinterpreted. First, let's talk about clarity or the lack thereof. Living wills are meant to communicate your wishes clearly, but they often fall short because of the language that's used in the document. Terms like extraordinary measures, terminal condition, or persistent vegetative state are subject to wide interpretation. What do these really mean in emergency situation? Does extraordinary measures mean a feeding tube, CPR, a ventilator? Worse yet, healthcare providers, especially in high-stress, time-sensitive scenarios, may not interpret your document the way you intended. Even your family members may disagree on what your language actually means. So what's the result? It can be misunderstandings that can delay treatment or lead to decisions you may not have wanted. Here's a case in point. There have been real stories where doctors misinterpreted a patient's living will and withheld care that could have been temporarily and life-saving simply because of ambiguous language. Reason number 2, they can limit treatment options you may actually want later. Living wills are static documents in a dynamic world. Medical science advances every year. Treatments that were once considered extreme or hopeless can become routine and effective. But your living will, created years ago, won't know that. If your document says, "I don't want to be kept alive by machines," that could end up denying you access to short-term interventions that may be entirely reversible and could lead to a full recovery. By the time you need medical help, your wishes may have changed, but your living will remains frozen in time. And remember, in many cases, you may not be dying. You could just be temporarily incapacitated or unconscious from an accident or recovering from surgery. But a strict living will may stop doctors from even trying certain interventions. So, in effect, you're locking yourself into decisions you may not have made if you were capable of choosing. Reason number 3, emotional distress for your loved ones. Let's talk about your family. Many people draft living wills to spare their loved ones of the burden of making hard decisions. But here's the hard truth. A living will doesn't always make things easier. In fact, it can sometimes make things worse. Imagine this. The family gathers around a hospital bed. The patient has a living will that says not to administer life support, but the situation is not cut and dried. Doctors say there's a small but real chance of recovery. Now the family must decide whether to honor the letter of the living will or fight for a chance of their loved ones to be saved. This creates guilt, doubt, and conflict, sometimes tearing families apart emotionally and legally. In contrast, appointing a trusted healthcare proxy or durable power of attorney allows for real-time, context-based decision-making with full awareness of the situation from the doctors. A rigid piece of paper cannot offer that flexibility. Number 4, better alternates exist. And finally, the most important reason not to get a living will is there are better options available. If your goal is to ensure that your healthcare wishes are followed, you'd be better served by a durable power of attorney for your healthcare or a healthcare proxy. This person is designated as your trusted person to make decisions when you cannot. They can access your situation, they can consult your doctors, and use judgment guided by conversations you've had, not vague phrases written long ago. Advanced directives tailored by legal professionals. Instead of a generic living will, some legal professionals help create advanced care plans that are more specialized and clearer and regularly updated. And of course, regular communication is a powerful tool. Talking to your loved ones about your preferences, having conversations, even though they may be uncomfortable, to prevent misunderstandings, rather than having a piece of paper. So rather than relying on a one-size-fits-all document like a living will, consider alternates that are dynamic, nuanced, and truly representative of your evolving value. So to sum it all up, living wills can be vague, they may limit treatment you'd otherwise want, they can also create emotional distress for your family, and are simply better, more effective alternatives out there. This isn't to say you shouldn't plan for the future. Absolutely you should. But do it in a way that embraces flexibility, clarity, and compassion. So before rushing into signing a living will, take a pause, think critically, and ask yourself, is this truly the best way to honor my values, protect my health, and support the people I love? Call us here today, right now, at Big Rock Legacy Law Group. Let us tailor a plan to secure your future.